All right, Larry, hey, thanks again for speaking with us about the patent evaluation procedure at Amazon. Last time we talked about the process. This time we're talking about after the process and what companies need to know. So with that, let's get started and talk about it from an accuser's perspective, things they need to think about if they find themselves or choose to use this procedure.
So starting off, a patent owner or an accuser should know that this process is very useful to take down an accused infringer's ASIN or their competitor. But importantly, it is not binding in future proceedings. And those include proceedings in federal district court. They include proceedings at the U.S. Patent and Trademark Office, and they can also include proceedings at the International Trade Commission. Still, it's not without risk to make this assertion. If your competitor, if the person you're accusing of infringement wants to fight this out by accusing them through Amazon's procedure, you can allow them to file what's called the declaratory judgment action against you. They can actually sue you in federal district court and say that your patent is invalid and never should have been issued, and that they don't infringe it anyway. It may also trigger an accused party to file a litigation at the U.S. Patent and Trademark Office to just knock your patent out. So Jeff, in general, as a litigator, what do these proceedings mean to you with respect to the Amazon process?
Well, like you said, Larry, it's not binding. So it's not binding on any of these other proceedings. But that doesn't mean that a patent owner or a seller, but a patent owner shouldn't think carefully. They need to think carefully about the positions they take, the arguments they make, because they can be used against them in these other proceedings. They are admissions, party opponent admissions, perhaps. So think carefully when you make those arguments, and understand that you may have started a bigger fight. In other words, your goal may be to stop them from selling a product that infringes, but you may have started this bigger fight in these other proceedings, and just be aware of that. But not forget that the goal of this Amazon patent evaluation procedure should be, from an accuser's perspective, to get that product taken off Amazon, to get that ASIN taken down. And it's very effective and fast for that purpose. But understand that this could be the beginning of a prolonged battle, and know that going in before filing this. But let's talk about it, Larry, from the seller's perspective a little bit, and what they need to think about if they receive notice or an invitation, as it's called in this evaluation procedure, things they need to think about down the road.
Well, the most important thing from a seller's perspective is they have to realize that they have been put on notice when they receive that notice. And that actually has some potentially important legal ramifications down the road. You've been put on notice that a patent owner thinks that you're infringing their patent. And that will, at a minimum, ensure that the damages clock has started. If you are later sued in federal district court and found to infringe the patent, you're going to have to pay damages to the patent owner from at least the moment that you're put on notice, possibly before, but certainly the damages clock is going to be triggered then. The other thing to consider is that being put on notice may also allow a later court to determine that you were willful in your infringement. And what willful infringement means is that you knew about the patent and you continued to sell your product and infringe anyway. And the import of that is that the damages that the patent owner might receive from you if you're found to infringe could be potentially tripled. And that can be a lot of money and very painful or crushing to many companies. So if you are hit with this, it is important to think about whether or not you're infringing, and especially if you are planning on just allowing your ASIN to be taken down and perhaps considering just relisting your product under a new ASIN, that might cause potential problems for you down the road when it comes to willfulness if you end up in federal court. So in future webinars, we're going to talk a little bit more about these proceedings. But Jeff, thank you for having me here today.
Yeah, thanks, Larry. And again, for those who haven't seen your first seminar on the procedure, I encourage them to look at that first. And the whole idea here is that we provide information to those smaller companies who may not know about this process, may not have the details that these larger companies have. And so hopefully it helps somebody out there. Appreciate your time, Larry. Looking forward to doing another one. Thank you. Bye-bye.